As part of our continued efforts to providing new and more engaging content, we have with us today Mr. T Srinivasaraghavan, former Managing Director of Sundaram Finance, for an in-person interview where we pick his brain about his role in Sundaram Finance, particularly with respect to dispute resolution and arbitration, and different things that he's seen in the financial sector. We believe this interview would be very refreshing to hear from someone from the industry who can inform us about the practical realities and ground level aspects of arbitration that as lawyers we may not get to hear every day. So I hope this is an interesting and engaging interview for all of you. Thank you so much, sir. Thank you for taking out your valuable time and agreeing for this interview.
My pleasure.
Very happy to have you here. To set the context for the interview, if you could share some details about your role and experience with Sundaram Finance and your experience, that'll be great.
Okay, yeah, that's a long story, but I'll keep it very brief. I served Sundaram Finance for 38 years in various capacities. The last 18 years of those 38, I was the managing director of the company. So yeah, I guess it's fair to say that I spent almost all of my working life working for Sundaram Finance. So that's a really long story in brief.
No, that's truly a treasure trove of experience for us here. So I'm really glad. So considering, arbitration is something that I want to delve a little deeper into and, speak to you about.
Sure.
How has arbitration served as a method of dispute resolution at Sundaram Finance?
Well, okay. Let me give you a simple but direct answer. In the kind of business that we did and do in Sundaram Finance, which is basically financing, disputes in loan transactions predominantly arise from defaults in loan repayments, right? So that is the primary nature of the dispute that we're talking about. And as you know, the raw material for any banking or lending business is money. So essentially, the business of any lender is to lend the money and make sure that you collect it back, preferably in a timely fashion, right? I mean,
definitely.
If I oversimplify the business,
helps us even more.
Yeah, but that's what it is, right? You give money, you collect money, and there are specified due dates on which the money is to be paid. If they come in, it's fine. If they don't, then that's when the problems arise. And even here, there can be delays and then there can be defaults, which in my book are two different things. A delay is something where for, valid business reasons or valid environmental reasons, people may miss an installment by a few days. We are not talking about this. We are talking about defaults, right? So that is where arbitration comes in, because in the old days, when we didn't have something called arbitration, you then basically went to a court and then effectively forgot about it, right? Because it took forever. So what arbitration really did for us is brought in a fair and expeditious decision-making process, right? Especially after the amendment to the Arbitration Act in 2015. The arbitrator today is clothed with, much greater powers to deal with a dispute within a statutorily specified timeline. That, I think, was perhaps, at a practical level, I'm not talking technically, I'm not a lawyer, but practically, I think that's where it's really made a difference. Quicker dispute resolution without, the seemingly endless wait that we had to go through with the
typical court
procedure. So, in summary, I would say.
No, definitely. I think that's the thing we've seen with arbitration also, where court is there for a reason. Yes, definitely. But
Sure.
for certain kinds of disputes and certain kind of situations, we have also seen. But we wanted to see how, in the context of Sundaram Finance and their business, arbitration has helped.
Yeah, practically, I would say, this is where it's made the biggest difference. And of course, we can talk about specific instances and where and how it's worked. But short answer is, expeditious, time-bound, redressal of disputes, which I think
Definitely.
is
You, I think, have already, one of my questions was about advantages, and I think you've already pointed out the fact about how expeditious the resolution process has become.
right.
Are there any other advantages that you've seen that arbitration has played in businesses like Sundaram Finance?
There are many, but as I said, timely recovery, because money received today versus money received 10 years later, the value of
Clearly.
that money is very different. So going back to my point about, timely recovery, let's say, and I'm being perhaps a little generous here, conventional litigation takes, let's say, 3, 4, 5 years, right?
You are being definitely.
Yeah, right. So, as I said, time value, therefore, is very, very critical, because if 100 rupees is due to us today, it's one thing to collect that 100 rupees, let's say next week or next month, versus collecting the 100 rupees 5 years later. Because 5 years later, thanks to inflation and thanks
It's
to
no longer the same
that
value.
100 rupees is not 100 rupees, right? It's probably half of it, or whatever it is. So therefore, I think, as I said, after the 2015 amendment, with the powers that were vested in the arbitrator, under Section 17, which was toothless before the amendment came, the interim measure of protection is the backbone of any recovery litigation, which originally was only available with the courts. Section 9, which is what we started with, was certainly a big step forward in that direction. But Section 17 has made a dramatic change in terms of the speed of recovery, right? Section 9 itself, when it came, we thought was quite revolutionary, because it was a huge improvement from what we were struggling with. But now, with the teeth that's come in with the new Section 17 regime, I think it's really been a dramatically different. And as I said, because there is a mandated timeline for completion of the arbitration process, I think that has been game changing.
Definitely.
Absolutely.
That's great to hear. As you said, I'd also like to understand a bit more on the specific arbitration proceedings that Sundaram Finance has probably been involved in, and your role in relation to those arbitrations.
Well, my role in the sense is I was the captain of the team, if you will. Sundaram Finance always had a very strong and well-manned legal department. And I think I wouldn't be wrong or boastful if I said that Sundaram Finance, over the decades, and this has got nothing to do with the time I was there, as a tradition, Sundaram Finance has always been a pioneer in the development of law. And in several instances, and the earliest case I remember was the famous 1962 Supreme Court judgment on hire purchase law, 62 or 67, I don't remember. But so, we've been in a position where we've pioneered the laying down of the law, especially relating to hire purchase, which is what it was in those days, right? And many of these cases, Sundaram Finance was at the forefront, not fighting a battle only for ourselves, but for the industry, because these became the standards that were laid down for the finance industry, right? And one particular case that comes to mind in the context of arbitration is the famous case of Sundaram Finance versus NEPC Limited, which went before the Honorable Supreme Court. And that settled the law on the maintainability of filing Section 9 applications before a court, even before arbitration was initiated, right? That was a sort of a standout landmark judgment, which, as I said, then came to benefit the entire
industry.
lending fraternity, if I can call it that. So I think that was one epoch, if I can call it. Then the decision of the Honorable Apex Court in Sundaram Finance Limited versus Abdul Samad, I think it is, that settled the law on the applicability and necessity of transmission of an award before filing an EP or an execution petition. This decision, once again, was a landmark decision because it removed the cumbersome and time-consuming procedures and the unnecessary costs involved therein before filing of an EP for enforcement of the award. So this effectively put at rest the conflicting decisions of various high courts on the issue because, typically because it was a new law, it was challenged before several high courts and conflicting judgments. So that was something, which was very noteworthy again. Interestingly, I think another thing to point out here is we took this matter directly from the district court to the Supreme Court, bypassing the remedy before the high courts by constructively interpreting the provisions of Article 136 of the Constitution of India. When courts were refusing to give effect to the order of attachment of immovable property passed by the arbitrator under Section 17, we approached the Honorable Madurai bench of the Madras High Court in Sundaram Finance versus P. Shaktivel to apply the principles of 136 CPC in giving effect to the interim orders, and we got a successful order by which all the district courts were directed to give effect to the orders under Section 17 for attachment of immovable property passed by the auditor. So today, I think I'm not wrong. I'm out of touch with ground reality today, but I don't think I'm wrong in saying that this is now more or less being followed by courts all over the country when it comes to enforcement of interim orders under Section 17. And, Sundaram Finance continues to play a constructive role wherever there are matters concerning the industry as a whole. It's not necessary that we litigate only because it concerns the company, but these are typically issues of a wider nature which benefit the fraternity as a whole, as I said. So these were some of the standout decisions that I can recall from my tenure. But as I said, this is something that started.
No, I think hearing you recall all these cases, and I think you rightly pointed out the fact that you've been pioneers in both coming up with certain aspects of the business, and therefore obviously disputes arose, and therefore leading the way for even the legal path that can be taken towards resolving these issues.
Right.
Thus resulting in these standard landmark decisions. So that's the reason we want to hear from your wealth of experience. So I think being there, all of that, based on what you just told me, I also must ask you, what typically will be the arbitration process for a business like the transport loan business? And when I ask you this, I mean like the key steps involved, including costs, challenges in the process, and how does this differ from any other business vertical?
Well, if you really think about it, and this is probably true in every kind of business, but I will speak, for the business that I understand and which I did for most of my life. I think all dispute resolution, right? Regardless of which business or which vertical of business. I think the underlying principle is follow the principles of natural justice. I think that is kind of the starting point, right? We are fully conscious of the fact that arbitration is an informal process which doesn't necessitate intervention of courts, right? And there is, the fact that we have this quasi-legal or quasi-judicial process, we're very conscious of the fact that it's not something that we can misuse, right, vis-a-vis the borrower, or even if you call him a defaulter. I don't think they are. The immediate thing is, let's go after him, let's, wipe him out. That's not the attitude. So this is typically a process which starts ideally as conciliation, right? Because before you actually take the step of arbitration, there are several opportunities that are given to the borrower. And as I said, for reasons beyond his control, if he is unable to pay, we have to be, realistic enough and, act with necessary probity in making sure that we've given him every opportunity to come good. It's only when that fails, then you think in terms of a legal process, right? Even for arbitration, because for us as lay people, arbitration is also a legal process. It may not be a court process, but it is a legal process. So essentially, it is, as I said, a step-by-step thing. So usually, if I can narrate it practically, the guy at the branch, for example, let's say a default has happened in Madurai branch. The guy on the ground in Madurai will reach out to the customer. He will talk to him. He will try to find out if there is a problem. Is there something we can do to help, etc., etc. And if the guy says, yeah, give me some time, and we'll give him that time. It's only when those promises are sort of systematically broken, then we decide, okay, this guy is probably stringing us along.
It must be to weed out that thing between delay and default.
Exactly, right? Exactly. So we would like to give every customer of ours the benefit of doubt. Our starting position is not that this guy is a thief or a defaulter or whatever. So it's only after exhausting due process, then you move into, the
resolution.
The resolution.
Intervention.
Exactly. At that stage, and the way, and we'll talk about this later, the way our agreements were structured in those days, it was a sole arbitrator. And before the 2015 amendment, being the managing director of the company, I used to appoint the arbitrator. That's what was the recital in the hire purchase or the leasing or the loan agreement. So the arbitrator was appointed by the managing director, to which of course the borrower gave his consent, because this was, part of the, terms of the hire purchase or lease agreement. And the beauty of this thing is, and I guess it was a strange role also for me to play, because the managing director in this particular capacity was actually a neutral person. I was not appointing the arbitrator as managing director of Sundaram Finance. I was appointing the arbitrator as a neutral person who would listen to both sides and come to a fair judgment. So it is by no means the case that the managing director was appointing the arbitrator, therefore he was answerable to the managing director, or he was going to do some favor to the managing director or to the company, right? So that was a very interesting sort of division of responsibilities for me when I first, had to sign these because all those letters had to be signed individually. And in the early stages, I used to wonder, how does this work? I'm appointing the arbitrator on behalf of my own company, but then I realized that, it was a slightly...
I think that's the reason why jurisprudence developed to sort of help
Correct.
clear that.
So then you realize that this was a different hat
you had
from the managing director's hat. And therefore, then suddenly you realize that, oh my God, the responsibility on me is now much greater. Because I must not only be fair, I must be seen to be fair, as they say about justice, right? So one had to be very, very mindful, very careful in terms of empaneling arbitrators. So if I can pun on it, appointing an arbitrator was not an arbitrary decision, right?
Fair enough.
So it was a very, well thought out process, and we went through, a whole number of iterations. And then we finally said, the best way to bring credibility to this is, let's invariably go for retired district judges, right? So, A, they have a certain credibility. B, they have all the knowledge of the legal process. And of course, within that, we did our own due diligence in terms of, it was not enough that a person was just district judge. Of course, we did our due diligence. We did our background checks in terms of making sure that we got people who were of the highest integrity, right? And as I said, natural justice is something that was at the core of our entire thought process. Whatever was done, whether it benefited the company or it benefited the borrower, it had to be fair, it had to be clean, it had to be transparent. So these were, the guiding principles. Yeah. So in terms of the flow itself, Section 21 notice followed by nomination of the arbitrator. Thereafter, he takes over. Then we step back, right? Our job is more or less done when the appointment is done. So, as I said, these are all experienced practitioners of the law. So, they were quite comfortable following the process laid down in CPC, Evidence Act, etc. But, without making it too complex, right? We, as Sundaram Finance, used to provide, as I said, several opportunities to the borrowers before we initiated the arbitration. But after the 2015 amendment and the judicial decisions against unilateral appointment of arbitrators, I think it was in 2018 that we decided to switch over to institutional arbitration, right? And I think, if I'm not wrong, this went into implementation in May 2019, about a year ahead of COVID. I must hasten to add here, we did this much before, this famous Perkins-Eastman judgment came from the sword.
Again, ahead of the...
Correct. Our action was not a consequence of the Supreme Court's decision. This is something because, of the 2015 amendment. And again, I think that has been a Sundaram Finance tradition. We never waited for something to be mandated. If it is the right thing, follow it, has been the principle that has guided Sundaram Finance for 7 decades. And I think it was no different when it came to that. So today, even the erstwhile thing of the MD appointing the arbitrator is gone, right? So it's now completely institutional arbitration, and procedures are as laid down by, whichever institution it is, which, whatever are the rules governing the conduct of arbitral proceedings.
been associated with NPAC right out of college, taking care of the newsletter.
Okay.
I was with a law firm doing corporate law, and then now I'm doing it independently.
Okay.
So, but we've always, in the newsletter, we always want to hear from, people from the industry, because we keep listening to our own selves all the time.
Yeah.
So, was it interesting or was it a pain for you to look at arbitration, considering, that's not what you're...
No. See, I think two things. One, it didn't matter whether it was interesting or not, because that was our life. Right? As I said, கொடுத்த பணத்தை திரும்பி வாங்கியாகணும். Right? And if arbitration is the most efficient way to do that, of course I love it. Right? But beyond that, as I said, even though I'm not a lawyer, I took keen interest in, the legal processes and proceedings. So,
it's not there.
No. So I used to engage frequently with my legal team. I always wanted updates. And, over time, Aragoria, you also learn a little bit about the law, at least as it pertains to your domain. So, I used to be able sometimes to contribute to these legal discussions. Recently, of course, you have things like ODR, and I'm sure, this will evolve as we go along. But yeah, I think this is a journey. I think if I look back to how, things used to be when I joined Sundaram Finance, which was 40 years ago, a little more, and where it is today, I think we've come a long way. And I'm sure over the next 10, 15, 20 years, there will be a lot more progress that will happen. So, all good.
You had mentioned about institutional arbitration, and I'd like to pick your brain about it a little later.
Sure.
But given, we've heard the advantages that you encountered, are there any challenges or drawbacks to arbitration that you faced? And could you share some details on those?
Yeah, everything has its own pluses and minuses. I talked about timeliness. Certainly, yes, arbitration put a time frame within which, an award had to be passed, which was wonderful. But actually, the problems or the challenges began after the passing of the award. Because for enforcement of the award, we still had to rely on conventional litigation. We had to go to the courts. And no surprise at all, these were absolutely the lowest priority from a court's point of view, right? Because they're burdened with piles and mountains of cases. And therefore, execution is not at all something which is high on the agenda of any court. So, and in some ways, people who are intentional or chronic defaulters, they know this. They know, even if an award is passed,
they know the system better.
They know the system better. They know nothing is going to happen. So they take undue advantage. They play their own mischief. They play their own game. So that is definitely one of the drawbacks. The other thing I would say is that generally, our business is essentially a retail business, right? We finance trucks, cars, buses. So we were not financing projects of, 200 crore, 500 crore. That's not the nature of which big banks, etc. do. Ours is a very retail, individual-focused business. And sometimes we felt that, the provisions of the Act are probably more tailored to high stakes arbitration, right? Where thousands of crores, etc. are involved. And especially, I think the provisions of Schedules 5 and 7, they're not particularly favorable to small value arbitration. So this is potentially, I would say a drawback. Of course, there is a recent report of the Arbitration Reforms Committee, which kindles some hope, where the committee has proposed, I believe, a separate chapter for small value arbitration for claims below a threshold of 10 crores, right? We don't know whether this will actually get implemented, how it will get implemented, etc. But as I said, it is a ray of hope. So if that comes about, maybe, it will improve the process. But, these are, as I say, nothing is an unmixed blessing. There's lots of things we're very happy with arbitration, but then we wish it could be better.
This is something we typically will probably only get to hear from the non-lawyers on how it impacts, for small value arbitration, etc.
Yeah.
So, but yes, like you said, it's promising that there's probably something coming up in that regard.
Right.
Now, going back to my point on institutional arbitration, you did mention that Sundaram Finance made a change and took favorably to institutional arbitration. What factors influence this decision-making process, apart from the ones that you mentioned?
So, as I said, the issue had arisen, right? And there was some noises around the fairness of a sole arbitrator. While, I was very clear, my conscience, when I say my conscience, the company's conscience was very clear that, we followed the strictest and fairest of norms in terms of appointment of the arbitrator, so on and so forth. But to a third person, it may still look like, this is all one cozy arrangement. The managing director appoints the arbitrator. It's all, all like within the family kind of thing.
Needs to be
seen to be fair. So we thought, why, even if by and large people know the way Sundaram Finance works, even if there is an iota of doubt as to the fairness or the transparency, we said, let's remove that iota also and make it completely de-linked. So it becomes institutional. So nobody can point a finger saying that the arbitrator favored you or this or that or the other. So it was on all fours once we did. That's really the reason. As I said, this was way before Perkins and all of that.
How do you assess the effectiveness of arbitration clauses in contracts? You mentioned about the way this was drafted and all of that. So
right.
How does that help in resolving disputes promptly and fairly?
See, as I said, natural justice, that I think, and one of the articulated values of Sundaram Finance is something we call fair play. The Sundaram Finance has a Navaratna or Navagraha of values, 9 values, which govern the conduct of the business and its employees. One of those we call fair play. So our belief has been that the arbitration clause in the contract should reflect equal bargaining rights for both parties. It is not that we are the lender, therefore we enjoy a superior position or any such thing. No, it's a contract, right, between the company and the borrower. And therefore, the contract should provide a clear set of rules for procedure of appointment of arbitrator and make the seat of the arbitration in clear terms. That also sometimes, not so much in retail, but it has been a bone of contention, right? What is the seat of course, in big corporate law, it comes down to India, Singapore, UK and all that. We are not talking that. But even between Tamil Nadu courts and Andhra courts, sometimes there could be. But so I think as long as there is clarity in, ideally, nothing should be left to chance or interpretation. So whatever is the intent of the parties, if they are clearly set out in the contract at the beginning, ab initio, as you lawyers would say, I think that's good business conduct, right?
Definitely.
And it helps everyone because you don't then waste time, money, energy trying to interpret something that had been written into a contract 5 years ago, 10 years ago, whatever it is. So that's basically, I think, the approach that's driven us.
I wanted to pick your brain on, I think Sundaram Finance has also been involved in a few mediations. And if you could share with us how that has compared to arbitration. You did mention that, sometimes you go through that whole pre-process to arbitration.
Right.
But if there are any specific instances you can highlight, and also how it compares to the other two processes.
As I touched upon a little earlier, it's probably more conciliation and less mediation, because, as I said, for us, unlike for several other institutions where it's almost a process-driven thing, where automatically, if at the end of a certain time period, let's say 30 days, if a response is not forthcoming, it will trigger the next action. After 60 days, it will trigger another action, so on and so forth. So the actual decision-making involvement of anybody in the management is largely, negligible. Because, as I said, the process takes over.
So you would say this has been part of your SOP without even identifying a name or a technical term to it. It's conciliation.
No, I'm not talking about what we do. I'm talking about the practice
Process
that prevails in the marketplace.
Understood.
We have always taken a different view that, as I said, our primary objective in lending to someone is that we would like to see him prosper. I mean, that's the underlying philosophy behind the whole business that Sundaram Finance does. So our default response is not to put him out of business. Our default response is to see, can we have a conversation, right? Can we find ways to help him, keep his end of the bargain? If it means giving him a few extra days or a couple of weeks, will he sort of get back in line? Are there other ways in which we can help? Can we, to the extent of even advising him on,
Other options.
Other options. Could you look at this? Could you look at that? So I think conciliation has been, I would say, the underlying tenet in our approach to dispute resolution, right? And I think this is probably worth mentioning, during and immediately after COVID, during which time, several businesses, several entrepreneurs were, either wiped out or they were put to very, very grave difficulty. That was a time when conciliation worked really well. Of course, the Reserve Bank of India helped in terms of, providing for moratorium and restructuring of loans, things like that. So that helped. But within that, we were able to engage with our customers, find out, what their, unique or peculiar problems were, and we tried to fit our restructuring or moratorium or whatever in ways
Figure it
that
out
should
for them to make it work.
exactly. And even after doing all of that, some of them couldn't make it. So there we continued to have, because we knew that many of these customers had actually been very good borrowers pre-COVID, and their current behavior was almost entirely brought upon only by this horrible event. And therefore, we felt arbitration or litigation was not the default option, as I said. So we went through, and many of these difficult accounts, chronic accounts, we were able to, bring them back on track. Maybe we gave them some concessions, whatever it was, but they all came good, right? So I think, I guess if I can sum this whole thing up, what I would say is there has to be as much heart in this as there is head, right? Yes, of course there is a law, of course there's a legal process, of course you have the tools, arbitration, this, that and the other, but that cannot be the first
Default
option, right? You go
It needs to work where other things have not
exactly. Now, interestingly, just since you talked about mediation, we've had some experience in mediation, but not so much in terms of our dispute resolution, but because of the trust that Sundaram Finance enjoys with its large body of customers, we have sometimes been called upon to mediate in inter-family disputes.
Okay.
Right?
Literally go that extra mile.
Correct,
beyond
because for example, if it was a partnership between 2 or 3 brothers and there was a falling out, obviously the business also then suffers. So we were sometimes called in to play the mediator because we were seen as being a fair third party who will not take sides. And we have, I know at least definitely my predecessor, Mr. G.K. Raman, who incidentally was my guru and mentor as well, he has mediated several of those. I myself have been involved in 2 or 3, intra-family mediation. So we've had some experience of mediation, but
not the way.
not the way you asked it. Yeah.
Oh, that's very interesting. Still does give a flavor of where this sort of fits into the dispute resolution. It doesn't have to be direct business. Drawing from your experience, are there any international arbitration cases that you've been involved in directly or?
Thankfully, no. Though I must say that one of the things that I was privileged to do during my tenure was that we entered into several joint ventures with international banks, insurance companies. On the other hand, we also divested our portfolios, etc. So all of these involved, as a corporate lawyer, you will appreciate this, involved negotiations, and the arbitration clause was always a bone of contention. Where will the arbitration take? They always used to say UK or Singapore, and we used to say nothing doing India. We used to go and we used to say Chennai. They said Chennai is definitely not possible, maybe Mumbai. So we've had some tug of wars with our JV partners, but never had to invoke
Thankfully.
an arbitration clause. So I have zero experience of international arbitration.
Sometimes when you do that work in the contract, like you said, again speaking as a corporate lawyer, if you go that extra mile and ensuring the contract is tight, especially in these cross-border disputes,
right?
As luck would have it, it doesn't ever come to that situation, but it's always good that you at least had.
Yeah, exactly. We were very, very particular, very big. We used to argue this till the very end. I can't remember even a single case where we gave in. We said arbitration has to be India because, why are we inferior in any way, no?
And our arbitration landscape has also been improving tremendously to the extent where we can be a global arbitration hub.
We didn't see ourselves as being inferior in any way in terms of jurisdiction. Great. So, yeah.
So now that we're speaking about arbitration, how do you envision this and the role it would play generally within the financial sector, but also more particularly concerning the transport loan business?
Well, as I said, I think the implementation of this arbitration reforms committee report, I think, is probably something that could potentially be game changing. We don't yet know how soon it will happen and in what manner will it be implemented as recommended, or will it go through tweaks and changes? I'm not able to say. But as I briefly referred to a little while ago, if the chapter relating to small value arbitration, right, if that is implemented with a clear and definite set of rules, that I do believe, could make a significant difference, especially, since you talked about transport sector and, truck financing and that sort of thing. I think this could make a significant impact, right? As I said, we'll have to wait and see how it goes. And of course, enforcement of awards. I mean, that I think that is a crying need. So, because otherwise, effectively, you're looking at a paper tiger, right? You have this sense of vindication, saying, "Oh, I won this award," but it translates to nothing, right? So, if the award cannot logically and smoothly flow to enforcement, then I'm afraid it's a paper tiger. So that is something, again, I'm not a lawyer, so, I don't know how realistic or how naive I am being. But I think if by whatever means, if the powers that be, if they can bring in a mechanism for speedier enforcement of awards, I think the amount of good that it will do across the system will be phenomenal, right? Because I think the credibility of the process itself will dramatically then improve. I think from a lender's perspective, more importantly from the point of view of the economy, because think of the unproductive time that people are spending. Lenders, borrowers, arbitrators, lawyers. Yeah, some would argue, it's good the lawyers are making lots of money, so they're not complaining. Up to a point, yes, but I think if you step back a little bit and take a larger view, I think it's in some ways not an exaggeration to say it's a national waste, right? If so much time, effort, energy, money is being spent on a process which keeps dragging on and on and on, it is a national waste, whatever name you want to give it, right? So that's something I dearly love to see. One is the small value transaction threshold, and the second one definitely on execution.
You mentioned you weren't a lawyer and few things about lawyers, so I must ask, given we're talking about arbitration, which is very legal kind of process, as a non-lawyer, have you found this to be a necessary pain, or how has that fit into your role?
See, I think given the nature of our business, whether you are a lawyer or not, the legal process is an integral part of our business, because unfortunately, I mean, in a perfect world, you would wish that 100% of your loans will come back to you on the appointed date.
And we'll not exist.
Yeah, that's right. We had no need for lawyers, but we know that the real world is not like that. So yeah, there is always in our case, fortunately, a very small proportion of our total customer base went into this kind of situation. But even those, because primarily we have seen ourselves and continue to see ourselves as custodians of public money. So every paisa that we lend is not our money. We are, acting as custodians of public money. Therefore, it is our duty and responsibility to recover every bit of money that we can. And therefore, to your question, how involved was I? In many ways, I had no choice, because this was part of my job description, if I can call it that, right? And truth to tell, though, I have, no pretensions to understanding law, but over time, right, as you engage with, these arbitration cases, with legal cases, and as I said, some of the landmark judgments in which Sundaram Finance played a defining role in taking it before the courts, and sometimes in my capacity of being involved with the trade bodies, where we had to intervene on behalf of, the trade as a whole. So I did get quite involved in legal processes, and, I just enjoyed having these discussions. As I said, Sundaram Finance has always been blessed to have a very strong legal team. So we had and continue to have an excellent legal team, and therefore, I used to engage with them on a lot of these discussions. And one of the advantages that grey hair and a grey beard gives you is that you're able to recall something that happened 30 years ago and then say, can we apply that principle here? So on and so forth. Sometimes you made a fool of yourself, but I think, it does help, because you see so many of these cases, and then you begin to get an understanding of
the pattern,
of the patterns, and how the applicability of this law fits in to this situation. So as I said, it was very much an integral part of my job, and I'd say for most part found it very enjoyable, and because I had some great colleagues in the legal department, I had the benefit of learning from their knowledge and experience. So
that's wonderful. I'm glad to hear that. So, as you mentioned, I'm sure you've had to don the hat of a lawyer many times as well as part of your involvement in arbitration. You've also played many other roles in many institutions and trade bodies, including acting as a president of International Finance and Leasing Association UK, Madras Chamber of Commerce and Industry, director in Finance Industry Development Council, and many other bodies as well. So, how has dispute resolution and arbitration been approached by these institutions?
Okay, I haven't, donning those various hats, or those institutions were not engaged in litigation or arbitration at the time that, I served those institutions. So, it would be unfair for me to say that I understand how that process works. But if I can answer your question in a more general way, I think if you think about dispute resolution philosophically, right, I would say it's kind of uniform, right? I mean, ultimately it's two people disagreeing with each other, or two bodies or two institutions or whatever, who are not on the same page, right? So that is a dispute, right? In very simplistic terms, that's what is a dispute. So our approach, as I said, and this is consistent with our philosophy, is the resolution of a dispute is not equal to I win and you lose, or you win and I lose, right? And which is where I think the importance of conciliation becomes very, very important. Because, and I think I wouldn't be lying if I said that in an overwhelming majority of the cases where, we went to arbitration, I think both parties walked away from it believing that they both got, some degree
out of it.
Justice out of it, or, whatever. And as a company, I don't, it was never the case that we celebrated
a win.
A win like that, because it was never the intention that, as I said, our starting point is we want to see you prosper, right? Of course, there are the odd black sheep, the crooks, who try to take the company for a ride. Okay, those you handle differently, where they're wanton defaulters, willful defaulters. Okay, they require a different treatment, but that is a small minority. The overwhelming majority are people who, for reasons sometimes beyond their control, sometimes probably because of their inability, inefficiency, naivete, for a variety of reasons, businesses can go bad, right? There are no guarantees in life, much less in business. So things go bad. So I think, as I said, if we can reach this happy state where both walk away feeling,
they've
under
gain
the
something from-
circumstances, this is the best we could have got. I think that's a good result.
And that's the win.
That's the win, right? And I can even recall cases where several years later, the same person or somebody from his family has come back to Sundaram Finance to do business with us again. So there's no bad blood, right? I mean, there's no...
The relationship thrives.
Yeah, there's no ill will. I mean, they also understand that this is something we had to do because, as I said, we are custodians of public money. So we have to do our duty to protect, that custodial role. But beyond that, there's no hard feelings, there's no bad blood. So that would be sort of my...
I think that's also the role for which alternate dispute resolutions came into the picture,
Right.
As opposed to typical litigation. Because, as you said, as businesses develop and industries develop, earlier the kind of disputes, though the dispute is that there's a disagreement between two people,
Right.
the context in which these disputes arise, the context changed over years when things became more and more corporate and commercial. You
Correct.
needed these kind of resolution options that
Correct.
provided an opportunity or a platform for both people to feel like they've got something from
exactly.
it, which may not be possible in typical litigation. So even that had to evolve to match businesses. So I do see exactly, I can understand what...
Which also brings an interesting, point of view to online dispute resolution. I don't understand how online resolution works, but I worry, even in the context of business, one of the things that you don't want in situations like these is to become faceless, right? Because so much of this has to do with understanding human nature, right? There are millions of things in the world which can be taken care of by automation or by process or by SOPs or whatever, right? Millions of things.
But there are some...
There are certain things which require, a little more than what the book says, right? Which oftentimes happens when you and I sit across a table, maybe you're able to appreciate, maybe there's another way of looking at this, right? And then you sort of pull back and say, maybe I didn't think of that, maybe I should. And then suddenly what looks like a completely shut door opens a little bit, right? So I think that balance too is important, because if you go completely online, and I'm assuming that this will make it perhaps faceless in many ways, because if you're only dealing with facts, as they are stated, without the emotion that goes with or behind those facts, I don't know if that is a problem. But, those are necessarily the views of somebody from an ancient generation. I'm sure today's views are probably very different.
No, but I do see that, there is a shift happening, whether we want it, not, whatever opinions are there, definitely is a shift. So is this one of the emerging trends or developments you see, related to arbitration within the financial sector? And is this something...
I think clearly this is inevitable, right? I mean, and now, again, another thing which I don't understand at all is AI, right? What that is going to do, what havoc that will play, I have no idea. Whatever little bit I read or listen to on podcasts, more than anything else, scares me. Of course, there's lots of potentially exciting things about AI, but there's also very scary stuff. So how that will come into, the world of the legal system and processes is something I don't know. But I'm reasonably sure that, like everything else, this will also, I mean, for me, for someone from my generation, seeing a live telecast of the Supreme Court proceedings itself is a huge thing, no? Who would have thought? Right? I mean, that was the most hallowed,
institution that
secretive,
nobody could...
nobody you had, unless you wore a black gown or Unfortunately, you are in the wrong box. You had no place there. But today, it's on prime time television, and you can watch people present their arguments, and the Chief Justice responding and stuff like that. So already, I think that process is on big time. And certainly, as time goes by, we're going to see more of this. And for good reason. I think, if we can do away with these big stacks and bundles, which I remember used to fill up valuable real estate in our office, all these. So those are all obviously very desirable. And even online, as I said, I'm just expressing an apprehension. But if there's a good way to marry, technology, automation, digital tools, all of that, but not reduce the people involved to mere, numbers. I think then we're
that's
all
the balance.
Yeah, that's the balance. I hope we will achieve.
I think like any other thing, this has to play its role. We'll figure
Exactly.
out and then try and find the
Correct.
thread.
Like every pendulum, it has to
needs
swing
to before we get
violently.
the-
Yeah.
But this is the balance we need to, work towards.
Yeah, I would hope so. Yeah.
Based on your experience, what advice would you offer to other members of the management, particularly in this sector, in the financial sector, regarding arbitration or dispute resolution strategies?
Yeah, as I can only repeat what I said. Of course, we need very strong processes. Documentation, as you said, should be really tight, because again, for the same reason, we are not lending our personal money. I mean, it's the public's money that we deal with. Therefore, we, in terms of our preparatory, in terms of our homework, must be perfect, right? We should document everything absolutely perfectly so that we leave no room for interpretation or for someone to take advantage and thereby, either defraud or cheat or whatever the company. That is the primary responsibility of anyone who runs any business, especially a lending business. That's one part. Now, when it comes to, the event itself occurring, and then you have to now draw from the contract to go into enforcement. That is where, as I said, I wish it weren't a, cold-blooded 30 days, we'll do this, 60 days that, 90 days that, cut, right? And again, the reservation I have with ODR is the same thing, right? So it removes the human emotion from this. I personally, and I don't know whether it's relevant in this day and age, but this is what I've practiced, all my working life, and therefore I cannot be a hypocrite and recommend something else. I will only recommend, what I believed in and practiced, all my working life, which is to say, go step by step. I think give the borrower, even if he has this tag of defaulter, give him a fair chance, right? Try and talk, try and see if, we can find acceptable halfway houses, right? If we can, through a process of conciliation, arrive at, because even from a time and expense point of view, arbitration still, there are multiple hearings, and, if the seat of arbitration is Chennai, and the guy has to come from Jabalpur, it's cost, no? All said and done. I mean, maybe less expensive than the court process, but it still cost. It's time away from his business, so on and so forth. Therefore, as I said, step by step. If we can do this through sensible negotiation, conciliation, and settle it, ideally, that's what we should do. If they are intentional defaulters, willful defaulters, that's a different thing. You treat them on a different footing. I mean, there will always be a few of those.
Now that we've discussed different aspects of arbitration and how you've been involved in all of that, based on your experience, what would be, pieces of advice that you'd give for other members the management, particularly in the financial sector, when they approach dispute resolution and arbitration?
Tough question, but I don't even know that I'm competent to advise anyone, but experience sharing, if I can call it that, would be and I'm repeating myself necessarily because I alluded to this a couple of times earlier during the conversation. Let legal processes be the last resort, right? I think there's several things that we can do as people, as businesses, to resolve disputes merely through interaction, through conversation, through reasoning. I think that should be the first. That should be the first resort. And surely, it's not. It's unrealistic to believe that it'll work in every instance. It won't. Then, of course, logically you proceed. Let's do that. So that would be point number one. Number two, as I said, I think the human element in all of this is very important. It cannot be a totally faceless and, dare I say, heartless process, because we are dealing with human beings here, human emotions are involved. So that should always play a role. And this is not to argue that we shouldn't do, or we shouldn't sort of get excited about all the great things which are happening in terms of digitization and automation and ODR and as an AI. There's a bunch of things happening and it's wonderful. I mean, all of those things should happen, but I don't think it's either or, right? All of these things are great tools, great enablers, but ultimately I think
shouldn't lose sight
the
of
human judgment is still something which is, I think, invaluable, right? I mean, the human judgment is something very special.
Definitely.
And I don't think that should be ignored or thrown out the window because we have all these great tools and technologies and everything else. So I would argue for, a judicious sort of blend of knowledge, experience, all of that, but using the modern tools that are available to us, the modern, whatever enablers that are there, with a view to ensure, of course, timelines are dramatically reduced, because that's the bane of, our legal system. So I hope that will happen. And two, as I said, the interests of fair play, natural justice, whatever, those are met. I think, that would be one. And I guess, of course, again, something I talked about in the context of what we did in Sundaram Finance, but I think what I hope and wish will become the norm is that everyone moves to institutional arbitration. Because, of course, there is a case currently before the Supreme Court where Finance Industry Development Council, FIDC, has implemented itself in this whole thing of sole arbitrator.
Okay.
And because I think the Delhi High Court gave a contra view on the Perkins judgment. So we are before the Supreme Court now pleading that they shouldn't push for implementation of the Perkins judgment, and saying it's unrealistic. Which defaulter is going to sign up for that? So to protect the interests of lenders and the banks, so on and so forth, it should be. So that is on. But while so, I do think, again, from point of view of transparency, from the point of view of fairness, and to remove any doubts as to conflict of interest, this, that, and the other, just move to institutional arbitration. Then there cannot be any accusation of, somebody is unduly influencing somebody. You hand it over, the institution takes over, they appoint A, B, or C, over which neither one has a say. So that becomes truly arm's length. So maybe everyone should embrace it. We did, as I said, because we felt that was the right thing to do. But the time has probably come when that should more or less become the norm. Yeah, is what so those just some broad
Definitely.
thoughts.
Thank you so much. I think even, I mean, apart from each point, even this summary of, what points need to be kept in mind, truly drive home the key driving principles in any decision-making process around dispute resolution. Hopefully, that's the last resort. But if it comes in, is targeted a default or a dispute, then these truly will guide decision-making processes. I must thank you a lot for taking this time again to, delve deep into each of this. And I think the one that's very refreshing is that we get to hear practical, on-ground experiences that inform both us as lawyers in what we've been doing and what we will do going forward. This flavor of exactly how it fits in from the other end really helps us, and I think that's the best part of this all. And thank you so much again.
Thank you. I should thank you because I don't know. I have the least qualifications to speak on the subject of anything law, but as I said, this is really about experience sharing, right? I'm not at all. None of what I said was from the position of having been a managing director or any of that. These are lessons that I learned over a journey of 40 years. Real life situations where we encountered situations, people, whatever, and it's that flavor I tried to bring. Hopefully some part of this at least makes sense to some of your readers, viewers, whatever. And if it does that,
Experience is the best teacher, and more than happy to hear you.
Thank you very much.
Thank you.